Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we are back in Calloway County with injury attorney Jeff Roberts. Jeff, how are you?
I'm doing good, Jim. How are you?
Buddy, I'm doing good. Glad to be back. Glad to be back down in Murray. So today we're going to jump into a topic that it's called comparative fault, and that's something that I think a lot of people are not aware of. There may be some confusion about it. So I thought today would be a great way for you to kind of clarify what is that and how does that impact somebody who's actually been in a collision. So let's talk about this. Kentucky's a pure comparative fault. Take it from there. What is that? What does that mean?
Comparative fault is something that you probably have never heard of unless you're gone to law school or been involved in a litigated personal injury case at some point in time, and even then may not have heard of it from that standpoint. For a long time, a lot of places had what was called contributory fault, and if it essentially said if you contributed to the accident, then you couldn't recover for any injuries that you received. Comparative fault developed several years ago, long before I started practicing in the early 90s, and Kentucky is pure comparative. You can have differences in comparative fault, but what it essentially means is with comparative fault in Kentucky being pure is if you're involved in an accident, a lot of times in an accident, there can be multiple causes. There's not just one cause. Occasionally there is. Frequently there is just one cause. If you're stopped in traffic because whatever, there was roadblock up ahead or traffic accident up ahead or road construction that's got it, and you're stopped and a car comes up and plows into the rear end of your vehicle because they're not paying attention, they're solely at fault. You're not at fault any at all. Same with if you got a green light and somebody runs a red light and hits you, they're solely at fault. You're not at fault at all. If you've got stop signs, who has the right of way? You've got sometimes a dispute as to who has the right of way, or situations where somebody is slowing down because they think they see a deer off on the shoulder and they think it's going to run out, and they stop when there's really no need to, and somebody rear ends them. Person should have paid attention and not run into the rear end, but also the person you don't stop on a roadway without cause. So both of them are at fault in that situation. And in Kentucky with pure comparative, the way it works out is whatever percentage of fault that is assessed to you, then you don't recover that percentage of your total damages. So if a jury or a fact finder, it's normally a jury, you could try a case to a judge as well, but most of the time these are tried to a jury. So if a jury apportions 20% of fault to you and then says your total damages are $500,000, then you lose 20% of that $500,000, or your recovery would be 80% or $400,000 in that setting. So that's kind of the way that it works from that perspective. Some states, now that's how Kentucky is. Some states still have where if you're 50% or 51% fault is assessed to you, then you don't have any recovery. That's not the way it is in Kentucky. So if you're 90% at fault, you can still recover 10% of your damages in Kentucky. You don't get the 90% that's from your causative fault, but you get the 10% from the other person that caused, or from their insurance company,
So some of these other companies actually have a threshold limit, and they said the other person has to be proven at 51 or more than 50% at fault for you to even have a claim, right?
Correct. That's I don't practice in other states.
Right.
I know other states have had that in the past. I haven't looked in the last 6 months to see if they've changed it, but I know there were states that border Kentucky that had those type of fault patterns in the past, because I've talked to attorneys there when they have a case that could be brought in both jurisdictions about which states may be the best to bring the case in, and that's one thing I always bring up is Kentucky's peer comparative. And I've had others say, well, yeah, if the injured party is considered 50% or greater in this state, they don't get any recovery. And so it varies state to state. Kentucky, though, has been peer comparative. I've been practicing for over 32 years. It's been peer comparative ever since I've been practicing.
That seems like it's a little bit easier to recover, and I think you kind of just basically said that, right? I mean,
It is. It's easier to recover.
It's not an all or nothing kind of thing.
It's not an all or nothing. It's easier to recover from that standpoint, but it just makes common sense, in my opinion.
Yeah.
Some people, I've heard people argue, well, if you're greater than 50%, then you shouldn't be able to pursue it. Well, if you, even though you may be greater than 50%, your damages may be substantially greater.
Yeah.
Than the other person's damages, but essentially saying, okay, I'm a big personal responsibility and corporate responsibility person. If you're at fault in causing someone problems and causing them injury, you pay for it. If you break somebody's window, you pay for that broken window. And if they've got a double paned insulated glass window, you pay to replace it with a comparable window. You don't get to replace it with the cheapest window out there that will fit into that opening. That's the way I am, and I think that's fair.
It sounds like your parents raised you right.
Yeah.
I mean, when it comes down to it.
Yes, and I think they did. They did an excellent job raising me and my brothers. One brother. I think that's the fair way to do things. And so if I'm 60% at fault, then I only recover 40. The 40% that's caused by the other person, I don't recover the 60% that's caused by me, or vice versa. If I'm 40%, I recover the 60%. I don't recover the 40%, and that just to me is the fairest way to do it for everyone involved in it, because when you don't pay more in damages than what your fault is. From that, it used to be if you were greater than 50% at fault, you paid 100% of the damages, even though you may have only been 60% at fault, and that wasn't fair to the person either.
That doesn't even sound like that's fair.
Yeah, the peer comparative to me is much fair to everybody involved, both the injured party and the defendant. In the case, and you can have basically, as you and I've talked before. Some about this, not in the podcast, but when we were talking, you can have both sides actually having cases against each other from that. So my client could sue the driver of the other vehicle. The driver of the other vehicle can sue my client, and if both are found at fault, both actually have some recovery in that case.
That's interesting. A little bit earlier you said one driver could have substantially heavier damages, and
Right.
I'm thinking you do a lot of truck accidents,
Yes.
and I could imagine that. Okay, so maybe I was on the interstate there. I'm on I-24 driving down the road, and maybe I do something. I take my eye off the wheel or whatever, and then suddenly I'm in a collision with a tractor trailer. My damages are going to be significantly more. So it's nice to know that under Kentucky's peer comparative, I've still got a shot of getting some of that, significant medical injuries probably, and all
Right.
those expenses, paid for. I was a little bit at fault, but at the same time, maybe the trucker behind me was also at fault.
Yeah, I mean, they may have been going 85, 90 mile an hour instead of the posted speed limit or something of that nature. So, yes, you've got situations where, a lot of times you've got situations where both parties are at least somewhat at fault in causing the accident. And where you see it a lot, even when somebody goes in Kentucky, it's not just causing the accident, it's causing the injury. So if somebody rear ends your vehicle and you're not wearing your seatbelt, then they can apportion some fault to you for not wearing your seatbelt, and that causing your injuries to be worse, and you don't get to recover that aspect of your damages for if they say 20% is attributable to you for not wearing your seatbelt, then you don't recover 20% of your damages. So the accident was purely caused by the person rear-ending you, but you may not have been as injured if you had your seatbelt on. And if they put on expert proof of that, then they can actually reduce your fault some from that, which is another reason why everybody should be wearing their seatbelt.
Yeah.
Primarily because it does prevent you from being as injured as you would have been. So,
Wow. I hadn't even thought about that aspect, but yeah, it's the things I do or don't do, such
Correct.
as not wearing my seatbelt.
correct.
Could be
Yes.
an issue.
Yeah.
We talked a little bit about the threshold limits with other states, and we didn't name anyone specifically, but yeah, they can be different. When people hear us talk about fault, which is one of the cornerstones of any personal injury case, is establishing which driver was negligent. Let's contrast that a little bit with another term that we've talked about a lot, which is Kentucky's no fault. And I think a lot of people hear this and like, well, wait a minute, what is that versus the other? No fault's something totally different.
It is. I have a lot of people come in to see me, and they'll say, "Well, we had this wreck. I was sitting, waiting, getting ready to make a left-hand turn, had my blinker on, waiting for traffic to clear so I could, and this person rear-ended me." And I've got this damage, but everybody keeps telling me Kentucky's a no-fault state, so I don't guess there's anything I can do about it. And I've heard that a lot of times during my career, during the first conversations with someone. A lot of people misunderstand what the no-fault law is in Kentucky. Now, if you're a regular listener to this podcast, you already know, because we've discussed it before. From there, but there's only a very, very small part of Kentucky's motor vehicle law that is no fault. And all the no fault law is that if you're involved in an accident, the vehicle you are in is responsible for for your medical and or lost wages and some other potential damages up to the policy limits. Minimum limits are $10,000. You can purchase additional coverage over that, but most people don't. It's rare that I see people who purchased additional coverage there. So the first $10,000 in your medical or lost wages would come from the vehicle on the insurance, or the insurance on the vehicle that you're in at the time of the collision. And every person in that vehicle has that $10,000 of coverage.
Yeah, it's not divided.
It's not divided
separately.
among them. Each has their own $10,000, and that is, it come about because of fault. That law was passed back in the 70s, before Kentucky actually become a pure comparative fault state, and that what my understanding as far as practicing, but what I understand from talking to folks is that law come about because there was disputes as to who had the green light at an intersection, and then nobody's insurance was paying medical bills because they were saying, no, I'm not paying, we're not paying. State Farm, who insured driver one, was saying, no, our guy says he had the green light, we're not paying driver two's medical bills. Driver two's insurance said, our driver says he had the green light, so we're not paying driver one's medical bills. So nobody was paying the medical bills, and people weren't able to get treatment.
Yeah, because in a personal injury case, all of that's settled up at the end once a decision is made, right?
Yes, all of that is taken care of
settlement's
at the
made,
end. Yeah, once the case is resolved is when people get paid. So they developed the no-fault law in Kentucky, or sometimes referred to as PIP benefits, personal injury protection benefits, or basic reparations benefits, all three terms meaning the exact same thing. And so that small portion is no fault. But everything else in Kentucky motor vehicle law is fault-based.
Okay, and again, just another disclaimer on the no fault insurance. If you file a no fault claim, it doesn't cause your insurance to go up because again, there's no fault. You're not saying I'm admitting guilt. It's just a part of your coverage.
Correct. The regulations provide pursuing no fault or underinsured motorist coverage, which is again not based on your fault, but the other driver's fault, does not raise your insurance. Should not raise your insurance coverage at all.
Okay. Well, let's return to the primary topic of Kentucky being a pure comparative fault state, you know, one of the things that you as an attorney have to do with each case is to try to gather the evidence, because you're trying to determine who was at fault and prove it was the other driver, was the negligent driver who actually caused, you know, the accident. Ideally 100%, but you know, you take what you can get sometimes. Gathering the evidence seems like that would be extremely important. You want to kind of talk about some of the different evidence and things the driver could do to kind of help substantiate that claim?
Sure. There's a variety of different things that you can do after the injury, after the accident. First is obviously to reach out to police, get the police officers on their way out. If you know, when you call 911 to report the collision, if you know someone's injured, let them know that so they can get an ambulance on the way out. As well, if you are injured, then stay where you are. Stay in the vehicle where you are unless somebody tells you it's leaking or something. There's a safety reason that you need to get out. But if you are able to get out of the vehicle, then you know, if you've got your phone with you now that you know, everybody has a phone that's got the ability to take photographs. Take photographs. The police will get there. They will probably take photographs as well. But you go ahead and take photographs, because sometimes the police officer's photographs don't get everything.
Right.
And the more you have, the better off you are. So you can take photographs. If the other driver comes up to you and says anything, you know, says, "I'm sorry, I was adjusting my radio, not paying attention, or
Texting
I
my
was
wife,
texting, or I was on my phone, or my phone rang and I looked down." Whatever, make a note of that, document that later on. When the officer shows up, tell him, the driver told me, phone rang and he was looking down to get at his phone, looked up and rear-ended me.
Strange how that story can change.
Yes, that story can change later on. So you make sure you tell the officer that the other driver has already said that. From that standpoint, and then you've got, you know, you look at your vehicle, take photos of the other driver's vehicle as well if you can. Seek medical treatment, obviously, as well. But if you were wearing your seatbelt, make sure you let the police officer know you were wearing your seatbelt. And you know, most cars nowadays. Not most, every car that's manufactured now has an event data recorder on it that should document the seatbelt was being worn. But a lot of times, especially if it's severely damaged vehicle, before an attorney can get involved, that car may have already, property damage has been paid, the insurance company's got it, and that car's been taken off and crushed or whatever, scrapped, and we can't get access to that event data recorder. So if the police report shows you were wearing your seatbelt, we're in great shape. We don't have to have the event data recorder download to show that you were wearing your seatbelt there. But you know, any kind of that type of information, document that. If there's witnesses there, police officers do an excellent job protecting us. They do an excellent job when they come to investigate these, but a lot of the police officers are not accident reconstructionists, and they're not there to do an accident reconstruction. Usually the only time they come out for an accident reconstruction, call an accident reconstructionist out, I should say, is if there's a death or a very, very serious injury. And then or if they think there's a potential criminal charge, they may bring an accident reconstructionist out to the scene then to do a reconstruction of it. But that's very rare that occurs. So you know, documenting everything from that standpoint, and then in getting witnesses. You know, sometimes police officers don't get the witness information. I may have mentioned this once before, but I was going to Paducah to court one day, traveling down 641 between Murray and Benton, and a vehicle turned left, pulling a trailer in front of a car that was far enough in front of me I wasn't in danger, but caused a wreck because there was no way he was going to clear the road when he made the turn, and the vehicle in front of me hit the trailer. Tried not to, but they did. And I stopped, called 911, stopped, checked on everybody, waited till the police showed up, and I told the officer, the first officer that showed up, after he talked to the others, and he come over and he said, "Were you involved?" I said, "No, but I was a witness." And he said, "Okay, well, you can go." And I'm sitting there thinking, you didn't ask me who I was, any information about me or anything else. And I happened to have one of my business cards in my vehicle, so I got it out, went to the driver that was not at fault, and handed it the card, and I said, told him, I said, "I'm not trying to get your business. I can't handle your case anyway because I'm a witness to the accident." But he didn't get my information. If you're having trouble on them trying to blame you for anything, here's my information. I'm a witness to this accident. You or your insurance company can reach out to me. And nobody ended up reaching out to me because I'm assuming the other driver told his insurance I was 100% at fault and there wasn't any problem there. And that probably was the reason the officer didn't get my information, but he stood, in my opinion, still should have got my information just in case.
Just in case.
From there. So the officer may not get those witnesses' information. So if you see someone or someone says, "I saw what happened," get their information. If very quick, you can just, if you've got a smartphone, set it to video and say, "Do you mind giving me your name and phone number?" And frankly, I'd get you and tell me what you saw and get a witness statement from them right then and there if they're willing to do it. And then you've got it documented what they're saying happened from that standpoint. So anything like that you can do to document what happened, how it occurred, it can be very helpful later on when we're trying to do that. And be careful on what you say. Don't don't lie ever from that line in regard to cause of an automobile accident could be and likely would be considered insurance fraud. So you don't want to lie whatsoever, but you also don't have to say everything. So if you weren't wearing your seatbelt and the officer doesn't ask, don't volunteer that information. But if you ever ask, you got to say, "I was not wearing my seatbelt." And when you go seek medical treatment, they're probably going to ask. And even if you were wearing your seatbelt and you go to the hospital and they don't ask, tell them, "I was wearing my seatbelt." And that's showing up in the medical records. I've seen it where the police report didn't say anything about it. The emergency room report did, and that kept us from having to have that fight with the insurance. They brought it up because they said, "Well, police report doesn't say she was wearing her seatbelt," and I said, "You're correct. He didn't mark it yes or no either way." The emergency room visit said she was wearing her seatbelt, and in fact noted a red mark from where the seatbelt caught. So we didn't have to fight that issue any further in that case. So make sure you let people know those type of that type of information.
Right. And all of this, they seem like small factors, but when you're in a pure comparative fault situation, you want to make sure that you're building as strong of a case as possible so that you're not having to pay when, again, you weren't at fault, or you don't have to pay more than what you deserve to pay, right?
Correct. Yeah, you don't lose out on your damages because they're apportioning fault to you that should not be apportioned to you. Because if we can't establish that you were wearing your seatbelt, then that becomes a jury decision. Because the insurance company, even though they may not have proof that you weren't wearing it, they can raise that issue if there's not proof that you were other than your testimony. Then they can still come in and try to argue, well, these injuries wouldn't have happened if he was wearing a seatbelt, so therefore he wasn't wearing a seatbelt and he should be apportioned part of the fault. And if they got an expert witness to say that, that's going to be a jury determination. So if we got a police report said yes he was, we got a medical report saying yes he was, their expert's going to have a hard time saying no he wasn't wearing a seatbelt. And so insurance companies sometimes a lot of times insurance companies will do anything they can to try to reduce what they have to pay out to an injured party. And so you need to make sure you're thinking about that and documenting everything.
Well, let me ask you this as we wrap up today's episode. Who actually makes that determination? I mean, a lot of motor vehicle accident claims, personal injury claims get settled. They don't actually go to a jury trial. So in that situation, how is that division of fault decided upon? Is that the attorney negotiating with the insurance company, and eventually people reach a happy medium somehow? Or?
It can be at times. It just really somewhat depends. If you can, sometimes it doesn't make a lot of difference. If your damages are $250,000 total damages, and everybody agrees on that, and the insurance company's trying to say you're 25% at fault, but their policy limits are $100,000, and that's all their policy limits are. Frankly, I go back and say, okay, let's just accept your proposal that my client's 25% at fault. They're still entitled to 75% of the damages, which exceeds your policy limit, so pay us your policy limits.
Right.
And we'll go flat 25% out with on the underinsured to get from that, and then have that argument with them on whether I agree or don't agree that my client was 25%. Sometimes you can reach an agreement. Sometimes it's not as relevant because you're limited by policy limits from there. But if you can't reach an agreement in that regard, then ultimately it's the jury that makes that determination.
Okay, so it's not the judge, it's the jury that would actually do that.
It's the jury that would actually, 99% of the time. It's very rare that the attorneys try a personal injury case to the court, but you can try a case to the judge and not to a jury, and choose not to have a jury. Very rare that occurs, but the parties can elect to do that.
Okay, interesting. So, Jeff, you handle personal injury cases. You handle car wrecks, motorcycle accidents, trucking collisions, all across the state of Kentucky.
Correct.
You've got your office here in Calloway County in Murray, and then you've got your other office up in Christian County in Hopkinsville. But the nice thing is you've only got one phone number. So if somebody wants to get in touch with you, how do they do that?
Best way to get in touch with me is to call the office. It's 270-753-0053 if it's during regular business hours. Most likely you're going to have a live person answer that phone for you there, and that's the best way to reach me. You can email me at jeff@jeffrobertslaw.com as well, but phone is the best way to get in touch with me.
Outstanding. And of course, you've got a website with a contact us form. So again, jeffrobertslaw.com. There's a contact us form there if you prefer to just kind of detail some information in that and send it right in. Another great way to get the information to Jeff so he can reach out and help you.
Exactly. And I have a lot of clients that work midnight shift, and they're sleeping during the time that I'm working, or they're working during the time I'm working and they can't call from that standpoint, and they prefer to reach out by email or by that contact. And that's perfectly fine. If that's what you wish to do, that's fine. If you're going to call at 3 o'clock in the morning, you're not going to get anybody here anyway. And so if you want to just shoot an email, I'll respond to the email when I get it the next day. So.
Outstanding. Jeff, it's been good to see you. Thanks very much for your information on Kentucky's pure comparative fault laws, and we'll be back in a couple of weeks.
Thank you.
Take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.